We're going to get started. Hi, everyone. I'm America Josh, and welcome to Immigration Questions and Concerns under a new administration with Zjantelle Cammisa Markel, principal and founder of Cammisa Markel Immigration Law Firm. We are here because we've received a lot of questions in the last few weeks since the election, and we wanted to take this opportunity to address them all at once. We know that there's always lots of information flying around the internet and flying around social media groups, and we thought bringing Zjantelle here and having a single source of truth was the best way to move forward. So tonight is not going to cover every single topic about immigration. What we've done is we've tried to find the most relevant information, the stuff that applies to most of the audiences that Zjantelle has to her law firm and that America Josh has to our website and our community. So we've taken all the questions that you've submitted and we've compiled them into some groups. And we're going to be working through those from a 30,000 foot view and then narrowing down to some of the real specific questions that we've had from some of you. We are, a few points of order, we are recording this. So if there's anything that you don't quite understand, you can go back to this. It'll be on our YouTube channels tomorrow. And you can ask questions in the Q&A option in Zoom. So if you do those, I will mark them and I will read them as we go. And if that works, we've got a lot of questions and a lot of information to work through. So Zjantelle and I will try and get through a few of those. One thing before we get started, I want to let you know that tonight is to provide insight and guidance, but it is but it is by no means intended to be used as legal advice for any of your particular situations. Every individual situation is different. If you would like legal advice tailored to your particular situation, please reach out to Zjantelle and Cammisa Markel's team or your own immigration counsel. It doesn't matter who you talk to, but you need individual information. This is all giving you a bit of an overview. So enough intro. Zjantelle Cammisa Markel, super lawyer for I think the 15th year, is known to many of you as just a fantastic immigration attorney, answers lots and lots of questions, involved in lots of community organizations for especially the Australian community, but also lots of organizations related to immigration law. So Zjantelle, thank you very much for coming tonight and having a chat.
Thank you, Josh. It's a pleasure to be here.
So we've got lots to cover. And as I said, I want to start at the sort of most zoomed out version of all of this. And I entitled the first bit, here we go, separating rhetoric from reality. So we've heard things like enforcing immigration laws, the largest deportation program in American history, strict vetting, ending sanctuary cities. All these kind of terms are being flown around in speeches and in the media. And I thought we'd start there because understanding what the powers of the president are and what we've seen in the past and what we can expect for the future might be a great place to start. So do you want to give a bit of an intro, not only about yourself, but about where we currently are?
Sure. So yes, I'm Zjantelle Cammisa Markel. I've been an immigration lawyer for 25 years in New York City, office in downtown Manhattan, but we service our clients all over the world and all over the US. It doesn't matter where they move to. Help companies secure rockstar foreign talent, help individuals make their dream of living in America come true. So let's bring it to the topic at hand, which is the new Trump administration. What did we see last time? Yes, there were lots of big, bold statements last time as well, right? So there was the building of a wall, there was mass deportations last time. But we didn't necessarily see all those things unfold. We saw beginnings of a wall. The wall didn't eventuate by the end of the 4 years, right? Like the cost of that was prohibitive. Also, there were, the mass deportations that were enunciated last time as well. An interesting fact, actually, Josh, I know you're going to find this super interesting, is that there were actually more deportations under the Obama administration than there were under the Trump administration. And that's not just because Obama was in office for 8 years and Trump only 4, but it was, if you looked at year upon year, there were actually more deportations under the Obama administration. And then when you look at the deportations under the Trump administration, what you saw, and I know I'm saying this because we got so many emails from people saying, am I going to get deported? Am I going to lose my citizenship? Am I going to lose my visa? So many people concerned. So what's important to know is that the president can't actually make laws, but he can enforce or enact proclamations and make executive orders to enact and enforce federal laws. So what we saw was his focus on the deportations was on people with criminal backgrounds. And the reason was because the law allowed him to do that. There has
Yes.
always been a law in place that says that if you've committed a crime of moral turpitude, then you're inadmissible to the United States. And what that means is you either can't get a visa and you can't enter the US, or if you're in the US, you can get deported. So he was deporting people en masse who had criminal backgrounds or criminal convictions because the law specifically already was in place that said if you've got a criminal crime of moral turpitude, you can get deported, right? So he was just enforcing that. So I think looking at the three different branches of government, there's the executive branch, which is the president. There is the legislative branch, which is Congress, and that's who makes the laws. And then we have the judiciary, which are the courts. And so while the president can make proclamations to enforce federal laws that are already in place, he can also guide through his policies what federal agencies, how federal agencies interpret laws. So while they don't actually make new laws, they might issue a policy memo or a interim final rule that says, this is how we're going to interpret this now. We're going to interpret, I'll give an example that's relevant to maybe some of the Australians that are on here. Like, this is how we're going to interpret specialty occupation now. We're going to, interpret it this way instead of that way. And that's when we saw what that sort of the effect of the Trump administration, how it affected people was through these policies that were enacted through the government agencies. And the government, what's good to know about the government agencies in immigration are which ones exist, because there's different ones.
Yes.
People just lump it all in as immigration, but there's Department of State, and that's the consulates. So that's when people go to a consulate and apply for their visa, they're dealing with the Department of State. When you file a petition in the United States, so if you're filing a marriage-based petition here in the United States, or an L or an H or an E3 from within the US, an O1, that gets filed with USCIS, United States Citizenship and Immigration Services. So that's another government agency. Then we have CBP, Customs and Border Protection. That's the immigration officers at the airports and the borders. Then we have ICE, which is Immigration and Customs Enforcement, and that's who does the deportations.
The deportations, yeah. Yeah, and I think it's a really good point. To break it down into this, it really does start to define that when you hear sort of the bluster and the stories about what might happen, it's easy to sort of see one story about ICE, for example, and say, oh my God, how does that impact me? When in fact, you've probably never, like a lot of the people have never dealt with ICE. They may have spoken to the Department of State and USCIS, but they've never had an interaction with ICE. So it's important to keep that sort of perspective when we're doing this. And also, to your point, it is about, you might not have seen, because we had a lot of questions coming in about, what happened last time. And as you just said, it's not about creating new laws, because that is Congress's job. It's about how things were interpreted. So just to clarify, we didn't necessarily see new laws come into action during the last Trump administration, but we did see things change for people with visas and green cards.
Correct. And what we saw, so while the president can issue executive orders, right, that feel like new laws, or these government agencies issue policy and memoranda, what's important to know is that the courts can always squash these new initiatives and or executive orders. So what we saw a lot last time was an executive order or a proclamation or a interim final rule that got issued, and then a lawsuit came about. It was adjudicated in the courts, and the courts now have the final say on how laws should be interpreted and what the powers, whether it was in the constitutional power of the president or not, to make that declaration. So sometimes what we saw was something go into effect because a proclamation was made or an interim final rule was made. So it goes right into effect. And until the courts squash it, it's been in effect. So people are affected in that period.
Yeah, but it might only be a very short amount of time in particular cases.
But even a short amount of time can really significantly.
No, absolutely. So you just talked about, we've got the Department of State and USCIS. So I think it's a good place to start when we're starting to talk about impacts on visas. Do you want to define, and I know you briefly touched on this, but going to a consulate compared to an adjustment of status or filing a petition, do you just want to define the difference? Because I know there's always a bit of confusion about visas and status.
Yeah. So we can talk about it in the E3 context first, and then in other visa categories as well. But in the E3 context, you can obtain an E3 visa by either taking your E3 visa application to a US consulate outside the United States, and you make your application at that consulate. The immigration officer there adjudicates whether you qualify for the E3 or not, puts the visa in your passport, and then you re-enter and you can start working for that employer. If you file it, if you're in the US already, you can file a change of employer petition or a change of status petition to E3 or an extension of your E3 with USCIS. Also, if you're an O1, L1, H1B, you have to file with USCIS. In the US first, you get an approval. So it's a USCIS officer that it looks at your case, adjudicates it, and then issues an approval notice. What's important to know is the approval notice is not a visa stamp in your passport. So once you have the approval notice, regardless of whether it's an E3, H1B, L1, O1, you then, if you're going to travel internationally, you do need to, on your next international trip, go to a US consulate abroad, get that visa sticker put in your passport to then for your re-entry back into the US.
Okay, so in the last administration, did we see more impact, or was there a difference between how those two processes were impacted?
Yes, I think that under the USCIS filings, there were a couple of things that were impacted. So if we look at, there were laws that were enacted that were aimed at the H1B, but that trickled down and affected the E3. Yep. And those were mostly with respect to RFEs. So that's a request for evidence. And RFEs are issued by USCIS. So if you filed a case with USCIS, and it could have been an E3 or an H1B, we saw wage level 1 RFEs, and we also saw specialty occupation RFEs. And then for O's and L's, we saw there was a deference memo, which we can also touch on. But
yep,
you can, I can explain any of these in further detail.
Yeah. So, okay. So so we saw some impact to if you're applying with USCIS because of those RFEs, and we'll loop back to RFEs because we've got a whole section dedicated to them because it's so important. When it comes to the applying outside of the country, and so going and getting the actual visa through, so Department of State, through the embassies and consulates, did we see, like, I know this sort of coincided with COVID, so there were impacts. Did we see sort of particular impacts on particular locations? Did it become particularly important to go back to Australia for the Australians to get E3s, anything like that?
Well, during COVID, it was harder to go back to Australia than anywhere else. Quarantine and so forth. So we actually processed more visas not in Australia during COVID. And actually, predominantly most of our practice, unless people are going back to Australia, so at Christmas time, we see a lot of people renew their E3s because they're going back. But you don't have to renew your E3 in Australia or even get your first time E3 in Australia. So, and which consulates are available is ever changing. So during COVID, if, for example, there was a period where Mexico was very readily available, whereas now it's less available. London's a great consulate right now, has a lot of availability. So if you don't want to fly all the way back to Australia, you could very well go to London right now pretty easily. And has a lot of availability. So it's always changing. Yeah,
so it's going to be changing. So like how it's changed for the last 4 years and the 4 years before that, it's going to, we don't sort of expect any particular changes in locations or prioritizing a particular location to visit?
I don't think so. I haven't really seen that change much, even during COVID. It was more closures related to COVID because consulates wanted to not take third country nationals, right, and only take nationals of their own, but it was more because of social distancing than it was because of not wanting to take Australians. And so we're seeing more consulates open and available now than ever before, really.
Yep. Okay, cool. So one of the topics that you sort of touched on around this wage levels was one of the ones that we briefly touched on. So do you want to just explain, so we've got the prevailing wages, we've got LCAs, and then these wage levels. Do you want to just explain how that works and what the impact we saw on that last administration was?
Great question. So prevailing wage, we'll explain what it is, I guess, first. So the prevailing wage is the minimum wage a US employer has to agree to pay a foreign national for the job that they're going to do in their company. And that they have to file what's called an LCA, Labour Condition Application, with the Department of Labour. And basically the employer is saying, I promise to pay this person who's getting, and it's applicable to E3s and H1Bs. I promise to pay this person on an E3 or H1B at least the prevailing wage for this job in this geographic region. And the policy behind it was to protect American jobs, right? So they want to know that even though people think, oh, that's protecting me because I'm not going to get, I have to get paid at least the prevailing wage. But the government, the US government is thinking, well, we want to know that the employer is
getting a certain level
because you're good and not because you're going to take, a wage that's significantly lower just because you're a foreigner.
Yes.
Right. So, and the prevailing wage, typically when you file an LCA, there is a wage survey that is within the portal that allows you to look up that wage, and then the employer has to agree. And there's 4 levels of the prevailing wage, level 1, 2, 3, and 4, and there are different amounts. And typically they correspond with the person's education level and number of years of work experience. So one of the things that we did see under the last Trump administration, so Trump's administration's initiative last time was called BAHA, Buy American, Hire American. And in that, his focus was predominantly on protecting American workers as well. So one of the ways that he thought about doing that was by increasing wages of foreign workers, and specifically with the H1B, but this had a trickle-down effect onto the E3. And in October of 2020, we saw a significant spike in prevailing wages. And that lasted until December. So it was October 8th of 2020 to December 9th of 2020, where these prevailing wages were up like 40 to 200% on where they had been at. And so this had a significant impact on people because, I'll give you an example. Someone who is a marketing specialist,
yep,
who is making 65 grand a year, suddenly on October 8th, overnight, no warning, that prevailing wage jumped to 102,000 a year. So if you're, and it
not every employer is willing to just suddenly up your wage to 102.
Why you're like, awesome, now I need to get paid 102. Your employer's going, yeah, not so awesome, so bye-bye. We can't and continue to employ you anymore. So if your renewal fell in that period, it was problematic. And or if you just got a job offer, people were negotiating job offers, right. You got a job offer on September 30th, and you're talking to your immigration lawyer, and the company finally says on October 7th, yes, we're going to do this, and then we'll give you all the information, and they give the lawyer the information. Now suddenly it's October 8th, and you're like, oh, that $65 salary is not going to work. It's got to be 103 grand.
Yep.
Well, it's like, yeah, we can't do this anymore. So we saw people, job offers retracted, and or their extensions, their employers not wanting to file their extensions. So we absolutely had to find pivots and strategies to deal with that.
Yes.
And that's an example of where the interpretation of the laws was used.
Yep.
A lawsuit was filed, and it was. But
okay, so that's how it ended. That one was a month long, or a couple of months long-ish, and that was because a case was brought, and therefore they said that's an overreach, or that doesn't apply effectively.
Correct. But the but is really important, because so that ended in December, and then by January, the Department of Labour and DHS had already started different drafts of different versions of ways that they could increase salaries and prevailing
And this
wages.
is where it comes down to the language that they used in order to actually enact. So they're enforcing policy that's already in place, but how do they define exactly how they're enforcing that? That's when it becomes a bit of a cat and mouse.
That way didn't work, so let's try and find a different way. So,
yeah.
So which begs the question of, do we think we're going to see this again, given that we saw them try again even after it was squashed in the courts the first time, is very possible. And I think that also, Trump's concern is to protect American workers again. So we could see this.
Okay. So yeah, to recap, if you are applying for a visa or an LCA to go towards getting either an extension of your status or a new visa, that's when this became an impact because filing that LCA became a problem. So if you were if in the last Trump administration, if you were already employed and had your job and you were working and you were let's say E3 visa, you're 1 year into a 2-year visa, so you're not even thinking about filing an LCA. Did that impact those people, or was that left?
So if you were a year out, then it really didn't impact you because by the time it came to your renewal, the prevailing wages had already been restored to the pre-October 8th, 2020 wage level. What's good to know is that every year in July, the prevailing wages do change every July. So, but not that significantly. Like we don't see a jump 40%. It might be a few percent increase.
Yeah. Okay. Yeah. So it normally goes up, but we don't normally see it jump. So for the people that have already, they're already in, if we did see something like this happen again, if you've already got the LCA approved, you're just working and you're a few months into your job, for that particular type of change, we would not expect any impact. It's not retrospective on LCAs that have already been approved. Is that correct? Okay.
That's right.
And what strategies, like for last time, if people were in that like pain point, what were the strategies that you employed and what Cammisa Markel employed to work with that?
What's good to know is we don't know what the future is. So whether these strategies will work again, not sure, but I think they're good to know because do I think they could be used again? I think probably. So the first one that we used there were two: alternate wage sources and looking at alternate visa options as well. So alternate wage sources have always been an option for filing of LCAs. People usually use the one that's on the website where you file LCA because that one qualifies. It's readily accessible. click and do it.
Yep.
And to find an alternate wage source, you have to make sure that it complies with the USCIS requirements of that alternate wage source. So just finding an attorney that's willing to find an alternate wage source and make sure it complies to use that is definitely something that people should, align themselves with. And then secondly, if an alternate wage source didn't have a salary that would fit that person's wage, then we also looked at alternate visas that didn't have a prevailing wage attached to them. So that could be a J1, an H3, an E1, E2, a L1, even a TN potentially for some people. Was an option.
TN, I don't think most people are familiar. What's the TN?
Yes, so the TN is for people that have Canadian or Mexican nationality. Okay. And so for our predominant audience is Australians. So like,
sure.
Apply to me. But we do have a lot of clients that actually do have dual Canadian and Australian nationality, actually. So in the instance, we did look to, do they have a separate nationality? We actually looked at people's spouses, what was their status, what was their nationality? Could we approach the visa that way? And they could go on dependent status of their spouse, which wouldn't have a prevailing wage attached to it. I'll give you an example of the TN. We had a computer engineer whose salary suddenly spiked from 75,000 to 120. And the employer was like, yeah, we can't do it. We have Canadian nationality as well. So we were like, okay, we can do a TN. The nice thing about TNs is that they don't even have to go to Canadians don't even have to go to a visa appointment. Right. They just do their application to the border, to their either to an airport or to a border crossing. So you don't have to wait for an appointment, try and find an appointment. So during COVID, and even I think anyone who has dual Australian nationality and another nationality, always tell your immigration lawyer that your nationality, because even Singaporeans, Chileans, there are options.
There are options.
Nationalities beyond just Australian. So, and those options might not have the impact of any impact that might affect the E3 that you're currently on.
No, and as you said, there are alternative wage sources. There are the biggest take-home message, and I know we're going through lots of potentially scary issues that people might face in the future, but the overarching message is that there are always options. You shouldn't immediately, always options. You should speak to your immigration attorneys. You should say, lay it all out and say, here's where we are. It is not, none of these things that we saw in the past will necessarily happen again. And if they do happen, there are strategies to work through it. So we want to make sure that that is sort of a highlight of what we're talking about.
Yeah.
Yeah,
Align yourself with someone who has, I think when you're finding your immigration attorney, make sure you find someone that has a non-defeatist attitude, right? Like there were during COVID, just, some that were like, oh, well, the consulates are closed. What are you going to do? Like those kids
yeah,
can't do anything, right? We were knocked down every door of every consulate to find consulates, so just, align yourself with someone who will
go to bat.
Alternate strategies for you. Yeah.
Yeah. Speaking of strategy, so I know you mentioned that we saw RFEs, so requests for evidence. So people might be applying through USCIS and be sent back these RFEs. So I know that was one, especially during COVID, because people weren't traveling and they were applying through USCIS a bit more, which might not apply quite as much this time, but is valid because a lot of people do use this service. What were, you mentioned before, you mentioned wage levels and specialty occupations. Do you want to explain just what those kinds of examples were that we saw with RFEs last time when they really did start to tighten up the requirements?
Yeah. Before I go into that, I might quickly mention
Please.
that when an Australian says, yeah, well, I'm never going to use this anyway, I'm probably not going to file with USCIS because I'll just go to a consulate. There are sometimes instances where you think that that's what you're going to do, but then you can't. So for example, you might fall sick and be seeking medical. We've had clients that have ongoing medical treatment, so they can't be outside of the US for more than a week. They might be pregnant, giving birth right at that time. We had one hit by a car and in a coma right during the time of his renewal. We needed to extend his employment with USCIS because he absolutely couldn't travel, and he needed his employment extended because his health insurance was attached to his employment. And another one that people don't think about that I wanted to share tonight is if you've had any kind of arrest that is not resolved yet, then you definitely want to bring that up to your immigration attorney, because once you leave the US, it's harder to get back in if that arrest has not got a final disposition attached to it. But you can file with USCIS here and it not be an issue. So, and including DUIs as well. And if you've got a recent DUI, there are some consulates that have a zero tolerance. A lot of them will allow you to go see a panel physician. There are some that really, like, especially if it was really recent, will take a hard line with it. So if we have any clients that have that, we'll assess the situation, but sometimes we'll say, hey, we actually recommend a USCIS filing for you. Wait this out a little bit before you go to a consulate. So just wanted to bring that up because sometimes people
it's great.
To me. So the RFE, what did we see with the RFEs? Wage level 1 RFEs were,
so wage level 1 is when this is sort of the lowest wage level for a particular job. So you've applied, your LCA has the 4 levels and you've gone for the bottom wage level for a particular role.
Perfect. Thank you so much for immigration talk. So thank you for bringing me back. That's exactly what it is. And so it's applicable to E3s and H1Bs. And I bring up the H1B because there's listeners on here that are on that, or Australians whose employers might be switching them to the H1B. So it's relevant. So both those categories. And so what we saw was if your LCA was filed and your USCIS petition was filed with a wage level 1, the USCIS was coming back and saying, well, if you're at wage level 1, then we question whether this is actually a specialty occupation, because wage level 1's entry level. So maybe for entry level, you don't necessarily need a degree for this. So maybe it's not a specialty occupation. And then we saw specialty occupation RFEs, and that was they had narrowed the scope and the definition of what a specialty occupation was with respect to the degree part. So they said, well, a specialty occupation is an occupation that requires a degree in one specific field. So jobs that saw requests for evidence were jobs like marketing or a financial analyst. So for example,
broader.
Yeah. So for marketing, you could have a degree in communications, marketing, advertising, psychology. So they said, well, since you could have a degree in any one of these fields, it's not a specialty occupation because it's not a degree in one specific field. Financial analyst, you could have a degree in mathematics, finance, economics, commerce. They're like, no, this is so many varied fields, not a specialty occupation. So unless you were a lawyer, where you can only have a JD, or architect, only architecture, dentist, only dentistry, then those other jobs we were seeing requests for evidence on that specialty occupation.
Okay, so yeah, there were, and again, this is that kind of indirect, like it's a tightening of the interpretation. And I know one of the real frustrations we get from people when we talk about immigration issues is that there's not a strict definition of all of the terms. Like they use the term specialty occupation, but it doesn't exactly say like these are the 5 specialty occupations. It comes down to the interpretation, which is then what opens the door to administrations to be able to define how they interpret it.
Right.
Yeah. So for if you are thinking about applying for a visa generally, is there anything you can be doing in advance, or is it basically, again, just don't worry about things before it's happened and wait for, when you're ready to apply, approach it then? Yeah. What sort of your approach to your clients? Is it to do things in advance or more just to wait?
I think that most people don't need to necessarily worry because there are strategies that can be put in place. However, one thing that's good to know, if you are worried, if your wage is on the lower level of wages and you're worried that the wages may jump again, then you can actually file an LCA 6 months before you need it. So if your visa, your E3 or H1B expires anywhere between now and next June, you could already file your LCA. And you can
have the date, so you can have the 2 years from starting, so it's the start date that's up to 6 months in advance.
Yes.
Yeah.
So you could already file an LCA from now and you're protected from now until end of May. So that's a good strategy. That's a hot tip for tonight.
I like that one. That was a good one. Yeah, that's a take home. This is for the Instagram reel.
Yeah.
Okay, so we've talked a lot about E3, like E3s indirectly, and what I thought was there might be a good chance to talk about E3s because we had quite a number of questions come in just more broadly about the E3 being a specialty visa for Australians. Is the E3 in general, and I know you are, you don't have a crystal ball, so this is sort of speculation and we're speaking hypothetically, but do you see a risk to the E3 as a visa in general?
I mean, the short answer is I don't.
Yeah.
Predominantly because there was no direct attack on the E3s last time. It was a trickle down from what was aimed at the H1Bs. Also, I think the Australia-US relations are strong. They continue to be strong. We typically find out pretty quickly if the E3, if anything is happening with the E3. But I feel that it's solid. People should not be worried.
Yep. Okay, cool. So that includes, I know one of the other concerns was because the E3 can, in theory, you can apply for multiple E3s one after another. Those people that might have been here for a significant amount of time and how that relates to your ability to like migration intent and what is your long-term intent if you've had your 5, 6 E3s and you've been here for 12 years? Do you think that might be one area which is more at risk, or is it again just we don't know anything, we don't have any evidence to say that?
Yep. So I have a client he was one of the first E3s we ever did in 2005 when the E3 came out. He's still on an E3 now. We've never had an issue renewing it. Even during the last Trump administration, he's a great example because he doesn't want a green card anyway, but for tax reasons. So we've continued and we've never had an issue. There was a period of time where we were seeing people that were coming to us saying, oh, my E3 got denied and I was told it was because I was doing a renewal, or I was told I can't renew because I'm going to get denied because it's my 3rd renewal. We did those renewal, we never had a denial. So I think that I think those people that were denied in that period, when I looked at their cases more closely, and it wasn't our clients that got denied, by the way, when I did look at what had happened, and then we fixed it and got them approved, but it was a different issue and it wasn't necessarily because they had renewed another time. Okay,
so they're being nitpicky about particular or pointing to something, but not necessarily actually being the reason when you dug a little bit deeper.
So I think, and to this point, I'll just expand further on that because I know that there were some questions of people saying, well, what if I have US citizen kids or if I have a US citizen spouse? Will that affect my renewal on an E3 or if I've applied for the DV lottery? So all of those you can definitely still renew the E3. She's a client and friend. She's got 4 US citizen children and her and her husband are on E3s while the kids are, US citizens. They've lived here nearly 25 years. Again, no issues renewing their E3s. Clients that have gotten married, have a US citizen spouse, renewed their E3. You just want to make sure that you're trained correctly on how to answer these questions at your visa interview. It's all about how you respond to these questions. you know, and as long as you're not like, I'm going to, you know, enter the US
Stay here forever.
and then file for my green card, you know, you wouldn't.
Yeah.
So,
No, I mean, it's a very valid point, because I know, you know, the people that are watching today are the people that are obviously trying to stay informed about what's happening. So, which is probably the most valuable thing you can do, because as you just said, if people walk into interviews and they've got their, you know, stack of papers and they've got their file ready from their lawyer and they've got answers to questions, and again, it's not about lying, it's about understanding, you know, what you're being asked and answering those questions accurately. That can make all the difference. It's not necessarily about...
You can have the best prepared packet and answer a question dreadfully and everything goes south. So I think the prep before your interview is really important. So I think we have clients that are like, I don't need a prep. I'm like, yeah, well, you're having the prep. I don't care. Because the prep is so critical to making to that final success. And it's like, I'm not letting all my hard work like get destroyed. You know, something you might claim an interview. So we're definitely having the prep, even if it's a renewal, even if they've done this, you know, and I'm like, they're a pro by now. Always do the prep. And so if your lawyer says we want to do a prep with you, always say yes. It's really pivotal and important.
Yeah, and as these rules are being tightened up and as things are being looked at more carefully, being more knowledgeable about this is great. The other one we had from E3s was around the E3S, so the new status attached to the E3 dependent spouse and the automatic work authorization. So do you want, again, I know we can't exactly say, but do you see like that being a contentious issue, or is that a policy that was put in place and seems pretty firm?
I think that seems pretty firm. I do see clients still get admitted as E3Ds instead of E3S, and then get it fixed. And you have to get it fixed to make sure that you can get a social security number if you don't already have one. But you can get it fixed. We'll often give our clients a memo to carry with them if they're an E3D that explains the E3S, but sometimes, so this is a classic example of where USCIS made the rule that when you get entered, you'll be an E3S and you'll have status.
Yeah.
You know, the ability to work just from your I-94, but where CBP, the immigration officers at the airport, haven't been properly taught about it. And so they see you come in and then you're saying, I need an E3S, and they say your visa, then you've got the wrong visa.
Yes.
Sure, say E3S. And it's like, no, it says E3D. You have to enter me on E3S, and it can get confusing. So often with those clients, I say, just let them enter you, however, and fix it after. Because otherwise you get pulled into secondary inspection for 2 hours.
Nobody wants that. And do you have people that, even though E3Ss do get automatic work authorization, do you still have people that apply for EADs, so work authorization documents, separately from that?
Not so many, but we did initially, we did, based on industry. So we had a client who is an actor, and for her, the industry was just used to wanted to see something physical to show that she could work, and especially in equity roles and so forth. So for her, she just said, I really want the EAD because it just makes it easier. Trying to explain this E3S is so impossible that having the card is just easier. So but most of our clients don't.
And a good point is that every time you enter, you should check your I-94 online to make sure you've been stamped every time you enter, every single time. Pain in the butt. Silly system. All right. So you've mentioned a few times that the E3 trickles down from the H1B. Just quickly, like sort of, again, 30,000 feet, the difference between the H1B and the E3. So the E3 is only for Australians. I know that part. Is there what are the sort of, did the E3 come from the H1B? Is that why it's trickling?
So it actually came from a treaty with the US and Australia for Australia standing troops in the Gulf War. But they were like, how are we going to regulate this, and how are we going to set up the rules for it? So they set up the rules based on, so it shares some of the regulations of the H1B, including LCA. But the differences are, you know, some of the advantages of the E3 are that you can apply at a consulate. You don't have to file with USCIS. With H1Bs, you have to file at USCIS first. You can't just apply at a consulate. Spouses of E3 can work. E3Ds can work. Whereas a spouse of an H1B can't work until they've already started the green card process, and it's like kind of far down the line. It's very difficult. So this is something you definitely want to consider if your employer is thinking of putting you in the H1B lottery, if you're currently on an E3, because often they don't think about your spouse. If you're working at a big company and suddenly they put you in the H-1B lottery, you get selected for the H-1B, they file a change of status, you're now in H-1B status, and now your spouse lost their work authorization. So just
right.
If that's happening, and that will be coming up soon, right? H-1B lottery registration period happens in the first quarter of the year, right before March. What are the other benefits of the E3? I think the consulate, what's that? Oh, indefinite renewals. H-1Bs have a 6-year limit, right? And then you have to start the green card process. Whereas E3s, you can be here for 20 years, more longer. So that's a definite advantage. The only E3s are so much cheaper. Filing fees. The filing fees to USCIS are over $6,000 sometimes for H-1Bs, depending on the number of employees at the company. If you file premium processing, blah, 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 blah. So yeah, an H-1B costs at least three times the amount of an E3.
But there is a downside. So the advantages are I know we've talked about migrant intent just earlier. So is that sort of the pathways to green cards and things? I think is a lot of the reason that people might look to this as an opportunity. Does that mean to sort of skip one step? Does that mean that you can not apply for a green card on an E3, or is that the advantage of the H-1B? Because I know that's what a lot of people talk about.
So on the H-1B, you're allowed to have immigrant intent, meaning that you're allowed to actively pursue a green card at the same time as being on the H-1B, whereas on the E3, you're not supposed to have the intent of pursuing a green card at the time that you're applying for the E3 visa. But that does not mean that you can't go from an E3 to a green card. We do it all the time. We've done hundreds, thousands probably of them. And so it's just about making sure that you get the timing right. For going from an E3 to a green card. Sometimes if you have the benefit of switching to an H-1B, instead of going E3 to green card, the benefit of switching to an H-1B or an L if you qualify for an L, because there are some people that have come over on an E3, even though they qualified for an L just because an E3 was faster and cheaper. You could switch to an L or an H-1B again if you have frequent international travel needs while you're pursuing the green card. Because when you go from an E3 to a green card, there will be a period of currently it's like right around 6 months where you won't be able to travel internationally. So if you have a high frequency travel, a job requires you to frequently travel internationally, then
you need a different option.
Would be better. Yeah.
Cool. Okay, switching visas, because we had some interest about the O1s and L1 visas as well. So O1s for extraordinary abilities, L1s being the intra-company transfer, so being transferred within the same company internationally. What were the changes in the last Trump administration to these visas? Yep.
So the major, the memo that came out that significantly affected the O's and L's the most out of everything. Well, the O's, they did question how to interpret certain criteria, but the one that had the most impact was on all I-129 filings, actually. But from 2004 until 2017, there was this memo in place that said immigration officers should give deference to a previously approved petition if the parties are the same and the job is pretty much the same. So if you were extending your visa with the same employer and it's pretty much the same job and it's you, so the parties are the same, then the immigration lawyer should think that you'll probably qualify again for this because you've been approved by USCIS before.
Yeah.
So the Trump administration came in and retracted that memo and said no. And this was under the extreme vetting. They said every visa petition needs to be looked at as if it's a first time that person's applying. So you saw more RFEs on renewals at that point in time. If you had a weak O1, L1, then it was at jeopardy, whereas previously, and now restored, actually, as soon as Biden took office by April, it was already restored, the deference memo. So we have some clients on O1s right now that their O1 might not necessarily be too strong for their renewal. We're encouraging them to renew now.
Okay,
while
so the tip is now, yeah, so if you
memo will be rescinded again, right? So
okay, so there's a good chance, like that would make a lot of sense. That was an easy, clearly that it was effective for the Trump administration last time. So we would potentially expect to see that again. So the best advice is jump on it right away, start your applications now, because it can't hurt to get it out of the way and not worry about it in a few months.
exactly. And you can refile. Most extensions, you need to have a 6-month window. You can start that 6 months before it expires. But an O1, you could file a brand new petition at any point in time.
Okay, cool. That's, yeah, so love it. The okay, so that was the same, sorry, for the O1 and the L1. That was, they both have the same impact to the deference rule.
Yes. So L1s, you want to make sure in the intercompany transfers, usually they are managers and executives. They need to be managing people. So you want to be making sure that it's still a strong L1 filing, in that the company, you do have direct reports, at least 2 professional level direct reports under you, and you sit in a nice position on that org chart.
Yep.
And if not, you want to file sooner rather than later if you can.
Okay. And this is, I know I keep saying it, but like this is where your knowledge of understanding like all those sort of nuances, it becomes about the package that you put forward. It's not about the sort of exactly what it's the buttoned up presentation you do on the day that really makes such a big impact.
You know what? We've actually never changed the way we file our petitions anyway. So we've always filed them with as much evidence as would be needed as if it was a first time. If someone was going to look at this petition, we make sure it is buttoned up every time, right? So for us, it's not going to change. But with the deference memo, some people have taken an approach of like, well, maybe we don't need to put as much in. For us, we're more using it now with respect to the filing early, is more if someone doesn't have a lot of evidence to add.
Okay, yeah.
But if they've got a strong petition, then we'll not worry about
fine.
it. Just
Yeah,
say,
cool.
Stop.
No, great. F1s and OPTs. So I know we do have some students who sent in questions and curious about what the impact to them last time was. And if you're on an OPT, what sort of strategies you can be using from here on?
Yeah, so F1 OPTs were somewhat targeted last time. Nothing really would have affected our viewers so much. But what we did hear this time around was that Trump was eloquently saying that he wanted to give green cards potentially to foreign students that had completed bachelor's and higher level studies in the United States. So I don't know if that will happen. I don't know how the law allows for that.
Yeah.
But at least it's a positive outlook for O1s and F1s potentially.
Okay, so if people's OPT is ending and they're looking to transition onto a visa, what's sort of the best thing they can do now? Like if they're looking to go to an O1, for example, is there anything they should be doing now to prep for that?
Going from OPT, you're saying?
Yes.
Yep. So depending on what visa you're going onto, so say you're going onto an E3 or an H1B or an O1. So if you're going on to an E3, you might want to educate your employer already if you do have a job, or if you're applying to jobs, educate your potential employer or current employer about the difference between the E3 and the H1B, so that they know that we've had a lot of people able to get jobs because the E3, they've been able to advocate that the E3 is not the H1B, they're not going to have to be put in the lottery, and that they'll be able to be kept beyond the end of their OPT. So I think that's really important. If you're not Australian and you don't qualify for an O and you're going to need the H1B, then in that instance, you want to make sure that you align yourself with an employer that's going to be willing to put you in the H1B registration. You want to try and study in a field or change your major into a field that's a STEM field, because STEM graduates get actually 3 years of OPT instead of just 1. So then you've got 3 chances at the H1B lottery in that instance. So that's a pivot that you could make and to sort of position yourself a little bit better in that regards. O1s, I love it when clients come to us early in their OPT period, because we can strategize with them early on what they can do and how they can maximize their time in that year. Usually they get 1 year because they're not a STEM field, but all the goals that they need to hit in that year to best position their O1 filing. When someone comes to us, with a month left on their OPT and they haven't gotten any awards yet and they've gotten 0 press and they haven't really done any major contributions of significance, then it's like late. Whereas if you meet with your lawyer early in the process, you can go, okay, great. I'm going to position myself to get press. I'm going to position myself to, I'm going to submit Australians are always never putting their work up for awards.
Yeah.
And not even Australians. We have viewers on here, I know tonight, that are not Australian. So I think it's important for them to just position themselves and prepare early on and strategize and like try and hit those markers. So they have good evidence.
No, I love it. So preparation, education, being part of this webinar is your first step into doing that. And then speaking to your immigration attorney, speaking to Cammisa Markel, getting the process working. Okay, the next big one that we had was around green cards, because we had a lot of people sending in messages about they might have a strategy that they wanted to enact in the future about getting a green card. Did we see changes, and what do we expect for the application process for green cards? And I know there are, we'll defer, I'll ask you about the lottery specifically after we go through a few questions about green cards generally. So not the lottery, but other strategies and pathways from like visas to green cards. What do you see as some of the impacts, or what did we see in the past?
Well, last time, there were two main ones. One was under the Trump administration. One was a stricter application of the public charge rule. So again, a stricter interpretation of a rule that already existed. And then we also saw green card interviews for everyone under the Trump administration. It was mandated that anyone that was applying for a green card had to undergo a green card interview. And that was actually under the Muslim ban that was introduced. So I guess we could look at the public charge rule first. So that's a rule that's always existed, which is if you are likely to become a charge on the government, meaning that you are going to need government resources to survive in the United States, and become what they call a public charge, then you're inadmissible to the United States, meaning that you don't qualify for a green card. So before, say you had a marriage-based green card case, the only thing that you would have to submit is that your relative that's petitioning for you, usually a spouse, maybe a child, they had to file what was called an affidavit of support. And they had to show that, oh, look, I make enough income to support this person, should they not be able to support themselves. And that income that they had to have made was pretty low. If it was a family of two, it was like 25 grand a year. And that's supposed to support two people, right? So now what we saw under Trump administration, there was the introduction of a new form that was called the Declaration of Self-Sufficiency. And this had to be filled out by anyone applying for a green card, whether it was marriage-based, employment-based. And this Declaration of Self-Sufficiency was a form saying, yes, I'm declaring that I'll be self-sufficient and that I won't become a public charge. And so they really made you provide more evidence to show that you wouldn't become a public charge. So you had to show things like your credit score, your credit report, all of your assets, all of your debts, your liabilities, your bank statements. Did you have health insurance? If you didn't have health insurance, evidence that how you planned to get health insurance, because without health insurance, they don't want you going to the government to getting the government resources, medical resources. So, and then they did, they looked at your age and wage, age and wage. And so, they would weigh up all these things to determine, could you potentially become a wage or a public charge?
Public charge,
And therefore be inadmissible. Under Biden, we saw that go away. That form was no longer required. So, could we see that come back? Potentially, yes. What does it mean? It just means more paperwork when you file for your green card.
And then the interviews. Oh, sorry.
And then the interviews. So up until the Trump administration, I've been doing this since 2000, it's a long time. There were always green card interviews for marriage-based green card applications. Then COVID happened. And actually, sorry, let me go back. There were always green card interviews for marriage-based applications, but there were no interviews for employment-based applications. There's an overarching law, another example of a law that's in place and can be interpreted in different ways and used, right, for different purposes. So overarching law is that anyone applying for a green card needs to have an interview unless USCIS exercises its right to waive that interview requirement.
Yep.
So we saw USCIS would regularly waive the interview requirement for employment-based green cards. So we would see marriage-based green cards go for an appointment, but employment-based green cards, if it was filed as adjustment of status in the United States, would not go for a green card appointment and would just get issued their green card. Under Trump, under the extreme vetting, the Muslim ban, they said, okay, we need extreme vetting now. We need to know that, anyone we're giving a green card to is not a terrorist, is not, so forth. So we're going to make sure that everybody going for a green card has a green card interview. So now we saw marriage-based and employment-based, everyone going to interviews. Then COVID hit.
It was already slow. Yeah.
Had to slow down because everyone had to go to interviews and there's only so many resources. Then COVID hit and you couldn't go to an interview because the USCIS there was social distancing. So where they used to see 100 people in a day, they could only see 30 people in a day. And we saw these massive backlogs happen. So then what we saw was then we saw the Biden administration come in. Already under Trump, we started seeing the waiving of some green card interviews, particularly marriage-based ones. So if you file your marriage-based case with all of the evidence you would typically take to an interview, we were seeing the green card interview get waived. So now we file all our cases that way, and we have seen none of our marriage-based clients go for green card interviews. It's very rare. And same with employment-based interviews. We haven't seen any employment-based green card interviews on adjustment of status. So now the green cards started to get faster again because the requirement to have an interview was eliminated. Could that come back? Yes. Does that mean things can slow down? Yes. And there's also like other complications with slowing down the green card process, which involve the visa bulletin, but that's a discussion for another day.
So really, yeah, the impact was on the whole process really ground to a bit of a halt because all the steps there was more paperwork to do, there were more interviews to do, I guess the outcome from this in terms of this type of green card would be, if you're going to do it, you want to get your application in sooner rather than later, would be.
You want to avoid having to give your credit report and your mortgage statements and you might be putting in something like your mortgage statements and some of this evidence anyway as evidence of your bona fides if it's a marriage-based case, for example.
Sure.
Documents that you have joint documents with your spouse. So you're going to be putting in those documents, but if you're employment-based, you don't necessarily have to put in all of those. So yeah.
Got it. What about I know I mentioned the green card lottery. There's one that comes up all the time, especially during the last Trump administration. There was a whole bunch of talk that it was gone and it didn't go anywhere. It's done the same thing, as I understand it, every single year. Am I interpreting that correctly? It didn't change in the last administration at all?
No, but it was actually under scrutiny. There were two senators that drafted this act called the RAISE Act. And part of that bill, one of the initiatives under that was to eliminate the DV lottery, and Trump was actually supportive of that. Okay. One of the senators is still a senator, so could we see that come up again? Potentially, but maybe. That one does require a change in the law to happen, and it takes a while for laws to change. It has to go through Congress before, for that to happen. So I think it's around, it's definitely around this year. I don't think we're going to see that go away too quickly, at least. Yep.
Okay. And then what about the pathway for people that might be looking into citizenship? So if they're on a green card and they want to transition into a citizenship, do we see any changes for that process to filing for the citizenship process?
Yes. So there was a short window again from December of 2020. And it lasted until about March of 2021, when, again, the Biden administration said, no, we're not going to make this citizenship test difficult. We're going to restore it back to the way it was. So most of our clients were not severely affected, but the difference was currently, and what the test is you have to learn 100 questions for your citizenship test.
Yep.
They're American history, the civics test. And they will ask you up to 10 questions and you have to get at least 6 correct. Under the Trump administration and in that period, that window, the test was changed to learning 128 questions getting asked up to 20 questions and having to get 12 correct. So basically you had to learn another 28.
Yeah.
So most of our people are smart and we're fine and could learn 28 more when they've already learned 100. But yeah, the Biden administration said, we think this has been made unduly difficult, so we're going to change it back. So currently it's still that test of learning 100, having to get 6 out of 10 right. If you actually get the first 6 right, they only ask you 6.
It's done. Yeah, so you can count that way if you know you're doing okay. Okay, so, okay, and again, that's one of those ones where it's an interpretation and a modification to sort of a rule that was already in place. What about people that, I know we had a few emails and a few questions come in about people that have already got citizenship. Did we see any, like we haven't, sorry, did we see anything that would imply that that would be affected? So people, whether through, there's birthright citizenship, because if you're born in the US, you are given citizenship as a baby. And then there's people that have applied for and got citizenship through naturalization. Do those two pathways, they still exist right now? Were they disrupted during the last Trump administration, or do we expect any changes to those?
They were not, and I think it would be very difficult because it's actually a right under the 14th Amendment of the Constitution that anyone that's born in the United States or is naturalized as a citizen gets to maintain their citizenship. So the administration would need to change the Constitution to take away citizenship from people who are naturalized, like me, and half of a lot of our clients and half the people walking out on the streets right now, and or birthright citizenship. So it would have to change the Constitution.
Yeah, really. And that's, again, just to, I know I'm harping on similar topics over and over, but it is important to break these things down into their sections, because when you read a news article and you hear sort of the fear-inducing messaging around, what's going to change, you sort of group it all into one. And as you said at the top, there are lots of different organizations that are part of this. There are lots of different processes that are part of this. And it's important to look at the individual one that you're actually referring to, as opposed to looking at it as a group. I am aware of the time, but we've only got a few more questions, so I will keep on moving. In terms of, just to really quickly recap, and I know this isn't as relevant to the topic today, but in terms of the benefit of citizenship over green cards, why would somebody want to do that? Like, for people that are now thinking like, oh, should I be looking into citizenship because that might give me more protection in the country? What is the benefit of citizenship?
It does give you more protection.
Yeah.
So I think the analysis we do is we always look at where in the green card process someone is when they're considering citizenship. How long have they had their green card so far? Some people actually, if they think they're going to be leaving and not remaining in the US and they don't want to make the US their home for a long period, might actually find themselves giving up their green card because to avoid what's called an exit tax that kicks in at around year 7 or 8 of having the green card. But if they do plan on making America home for a while and want that ability to always come back and want the protection of remaining in the US, it's harder to get, you can't really get deported. It's very hard to get deported if you're a US citizen, but if you have a green card, it is still possible to get deported. So it does afford that protection. Also, you have the ability to vote. I'm going to tell a really quick story because
Please.
I think it brings this home. People love stories. So there was a guy who was not a client of mine. He was British. He actually sold art.
Subtle. That was great.
And he was talking to my husband, and my husband was like, doing a pop-up art gallery at the time. Anyway, my husband had said that, yeah, my wife's an immigration lawyer. He goes, oh, I've got this crazy story. So I'm talking to him and he's like, oh, there was a time, I had gotten off the plane at LAX. I was driving to where the car is parked not driving. So he was caught the bus to where the terminal is of the car park where his car was parked. He got on the bus and it actually turned out that the bus driver and someone else on the bus were in cahoots to rob him. Yes. And so they tried to beat him up. He beat up the guy on the bus pretty badly, broke his jaw in self-defense. But what happened in court was it was two guys' verdict against two guys' versions of the story against his.
Sure.
And the judge did say to him, if you weren't a citizen right now for this aggravated assault, you would be getting deported and losing your green card. So it's a good thing you're a citizen. Yeah, so in a situation like that, or you end up at a party and there's drugs there, and hopefully you're not going to those parties, but we have clients that we're at a party and there were drugs there and then they're foreign and they go, oh yeah, it's mine, because they think I'm the foreigner, I'm not going to get in trouble, but that's just silly.
Completely opposite. Yeah.
are getting deported because of that. If you're a US citizen, you're not going to get deported for that. You'll just go through the due course of the laws here. But yeah, controlled substance offences are really dire on your immigration status. So just
be really careful. That's
yeah. And including marijuana, which is legal in so many states, it's still illegal federally. So you never smoked, you never had a gummy, you never did any of that if you're on a visa or even a green card, because your visa can get denied, or you have to go through a waiver and have a very difficult time getting a visa and or citizenship if you have any controlled substance charge, including possession of marijuana.
Good one. Finally, the travel bans was the one big last question that we had a lot of. Do you expect there to be broader travel bans for people coming as tourists or for people coming in on visas? Will it become more or less difficult? I know we saw significant disruptions to people coming in last time.
Yeah, the last time most of the travel bans were related to COVID, right?
Yeah.
What's the Muslim ban? I think what people need to be cautious of, you mentioned tourists, is that this has been in place for a long time, pre-Trump, and still exists now, is that if you are trying to enter the United States on ESTA and you come from an ESTA country where you normally would get an ESTA, if you have traveled to any of the following countries anytime after March 1st of 2011, and the countries are, I have to remember these now, there's Iran, Iraq, Libya, Syria, Sudan, Somalia, and Yemen. And then North Korea was added in 2018 and Cuba was added in 2021. If you have traveled to any of those places since the last 13 years, then you will not qualify for ESTA and you have to apply for a tourist visa. So a lot of the people listening, like, that's okay, I'm not on an ESTA, I'm not coming in on an ESTA visa, that doesn't apply to me. Where we've seen it affect people is that their relatives are visiting them. So we had a client who was having his wedding. His sister had traveled to North Korea. She applied for an ESTA a week before the wedding. It got denied. She couldn't get a B appointment for a tourist visa in time. Couldn't get a visa issued in time. She missed her brother's wedding, right? So if you've got an important event coming and you're going to have people coming to visit that you think probably are going to just be able to apply for an ESTA, just make sure that they apply for that well in advance in case they do need to get a tourist visa, because they take longer than an ESTA to get.
No, I think that's a perfect place to go, because the whole concept of tonight has been about education and preparation and planning. So it's exactly the same point. If you want an ESTA, apply in advance. If you want to know about visas, make sure you talk to your immigration attorney. Make sure you keep educating yourself. I know that Zjantelle and I will both there'll probably be another one of these in the future if anything does change, and we'll make sure that we keep you in the loop. I think one of the most important things I've just written down here is take a deep breath, because a lot of the things, most importantly, we're speculating. We don't know, and Zjantelle will fully admit, we are estimating a bunch of things based on what we've seen in the past. And it's worthwhile being prepared, because if you can do some of the things that we've talked about tonight, like applying for an LCA in advance or preparing some more documentation in advance, that can all help. But we're not alarming anyone. We don't want to be alarmist. We don't want to, scare anyone, because there's no need for that. But being prepared is always important. So take a deep breath. I think this has answered, hopefully, we've gone through a lot of topics in a little over an hour. And I think, Zjantelle, the last thing I wanted to ask was, what do we sort of expect, what should people be looking out for? Is it just sort of keeping an eye on the news? Should they follow your Instagram and make sure that they get all the updates? Was that a perfect plug right at the end there? What should people be doing?
Instagram is really good. Yes, definitely follow our Instagram. Updates. Just, if you see anything and you're concerned, always feel free to reach out and ask questions, and get clarification rather than stressing yourself out. Often there'll be an answer that, that eases your mind and you're stressing unnecessarily. A good example is, and she might be listening tonight, is I had someone that actually tutors my kids in Italian, and there was a news article that said, oh, Trump's going to be getting rid of people's green cards, and immediately she's like, I've been so stressed, I'm stressed, look at this, and I said, this isn't happening. And she's like, I'm like, it would be impossible for them to do this and take this away from you, don't worry about it. She's like, okay, so just, if you're stressed about anything, always talk to a professional, Don't go to the internet. It's like, you have an ailment and you start Googling it, and next thing you know, it's
You've got the
the
worst of the
worst
worst.
ailment ever, but then you go to a
Yep.
doctor, and you're nothing. That's nothing. So same thing with your immigration, just always talk to a professional. And I know while friends can help, their situation's always different to your specific set.
Yes. Yeah.
So what worked for someone else may not be what's right for you. That's why it's important to speak to an immigration lawyer.
No, I love it. And on that, I'm gonna bit of levity. Is there anything you want to talk about that's outside of the seriousness of immigration topics and things we've talked? Anything you want to plug?
Oh, yes. Actually, speaking of fun things that lawyers doing, a client, Kelsey, who is actually in a band, and they're performing on Saturday, December 7th at 10 p.m. at Brooklyn Music Kitchen. And her band is called We Met in Therapy. And how cool. I am not a lawyer thing, but she has music talents. I don't have these other talents, but not that. So go to Brooklyn on Saturday night, support her. It'll be great for her to have some more Aussies there, and the band's awesome. So that would be lots of fun. And then you've got a tree lighting happening. And
we do December 8th. We're lighting the Big Aussie Christmas tree at bigaussiexmas.com. But yeah, I'd make sure that you follow Instagram. Cammisa Markel is a fantastic resource for all sorts of immigration issues. America Josh on Instagram and Facebook, and go to americajosh.com and make sure you join our newsletter. We send a newsletter out every Wednesday. There's always bits and pieces from Zjantelle and other fantastic resources on different topics. So make sure this is what we say, like and subscribe. If you do have questions, we are sending a feedback form tomorrow where you can ask follow-up questions. If we've got enough, I'm sure we can harass Zjantelle to come and sit with us one more time. That would be great. Zjantelle, you've been an absolute gem. You are a superhero of immigration law and know all of this inside out. So thank you very, very much for sitting here tonight and answering a whole bunch of our questions. We really appreciate it.
oh, it's a pleasure. Thank you.
And for everyone watching, enjoy, have a lovely night, and we will see you at the next one. Thank you very much.